Good evening, everyone. My name is Nuria Yu, and together with Isabella Conti and Rajesh Varghese, we are the editors of the Melbourne University Law Review for 2023. On behalf of the review, I would like to commence this evening by acknowledging the traditional owners of the land on which Melbourne Law School stands, the Wurundjeri people of the Kulin Nation. We pay our respects to their elders past and present and extend that respect to any Aboriginal and Torres Strait Islander people who are joining us this evening. We acknowledge that sovereignty has never been ceded and recognise our unique responsibility to contribute to reconciliation efforts as students and future practitioners of the law. Tonight, we are pleased to welcome you to the Review's annual lecture. Established in 2014 as an initiative to increase the Review's engagement with the broader legal community, the annual lecture is a valued fixture in the Review calendar. For example, previously, we have heard from the Honourable Mr. Kenneth Hayne on government contracts and public law, and the Honourable Justice Kristen Walker, who discussed when can a court's decision be ignored. This year, we are honoured to host Mr. Chris Maxwell as our annual lecture speaker. Many of you are familiar with Chris. Chris commenced practice at the Victorian Bar in 1984. He became Queen's Counsel in 1998. In 2005, Chris was appointed President of the Victorian Court of Appeal, a position he held until his retirement in July 2022. In 2015, Chris was made a Companion of the Order of Australia for his eminent service to the law and to the judiciary, his contributions to legal education and professional development, and his role as a leading supporter of human rights and civil liberties. In 2014, Chris helped establish Philosophical Foundations of Law as an elective subject in the JD program at Melbourne Law School. He continues to teach the subject in 2013, and many of his students have joined us in the audience today. As a matter of housekeeping, there will be an opportunity to ask Chris any of your questions at the end of an address, so please keep a note of them. Without further ado, please join me in welcoming Mr. Chris Maxwell.
Thank you very much, Nuria. I want particularly to thank the editors, Nuria, Isabella and Raj, for exemplary management of an ageing guest speaker, courteous, regular, helpful communication, and making it very easy from my point of view. So thank you for that. I also want to say thanks to all of you who've come along. It is, after all, 7 o'clock on the eve of a public holiday, and you might have been forgiven for thinking this was a bit much. Given that I can see, and we've just heard, that a number of you are students, it's obvious that students are a much tougher breed than in my day. I think if a lecture at 7 o'clock on the Thursday before Easter had relied on student attendance, it would have been pretty sparsely attended. So thank you for making the effort. It does me great honour that you've come tonight. It's a special pleasure to have been asked to present the Melbourne University Law Review lecture for several reasons. First, because my haphazard and largely uncomprehending undergraduate law studies meant that I was never in the slightest danger of being asked to be an editor of the Law Review. At least my recollection is that it was done by invitation, but as I say, I didn't experience it, so I'm told by the current editors that it's by election. And they were saying to me before that it was quite a hotly contested election this year, constituency of about 60, being all of those who are members of the Law Review, meaning the hard workers, and they put down their success to having been the teal candidates. So this is about as close as I've ever been to the Law Review. The second reason I'm pleased to be here is that over the last decade I've had a sustained and enormously enjoyable engagement with this law school, both as a teacher, and I'll be talking a bit about that, but for me, as importantly, as a collaborator, working in collaboration with academics in this law school in exploring areas of shared interest. Just one example, Matthew Harding and I convened a workshop in 2019 in this law school where we brought judges, barristers and academics together to talk for a day about how we could improve the contribution of legal academic writing to the development of Australian law, in particular how we could get lawyers and judges to make more use of that rich resource. That collaborative project reached something of a high point last year when the Law Review, wisely, published an article written by Matthew and me, a decision of the former editors, I should say, in which we brought his scholarly and my judicial perspectives to bear on conscience-based doctrines and the role of the judge as moral reasoner. More of that later. Thirdly, and most relevantly, I'm delighted to have been asked because the invitation has prompted me to think hard about the objectives and the benefits of the subject I teach, as you've heard, philosophical foundations of law. It was mid-2013 when we first pitched the idea for this subject to Carolyn Evans, then the Dean of the faculty. Both Carolyn and her deputy John Howe gave the idea their support, and we got underway in 2014 and we're still going strong. For those of you with good memories, two new first-year subjects were introduced at this law school in 1990. One was called History and Philosophy of Law, or HPL for short. Another was Torts and the Process of Law, or TPL for short. According to John War's marvellous History of the Law School, First Principles, these subjects were known because of their initials as HIPL and TIPL, respectively. Now, you might think that's funny. The problem is the same approach means that my subject, PFL, is inevitably known as PIFL. In this lecture, I will argue that learning to think philosophically about law is essential for good lawyering and for good judging. That being so, I will contend it must be a key objective of legal education to develop in students a capacity for philosophical thought. When I use the phrase thinking philosophically about law, I mean three quite different things. First, I mean thinking about the different ways in which ideas from moral and political philosophy underpin the development of the law. I mean recognising that substantive legal rules are shaped by underlying philosophical assumptions, conceptions and choices. Secondly, I mean thinking and writing about law like a philosopher, deploying the habits of mind, analytical rigour, logical argument and linguistic precision which characterise analytic philosophy. Thirdly, I mean philosophical self-awareness as a lawyer, having an understanding of the moral and political dimensions of the choices we each make about what kind of law we'll practice, how we will practice it, and what sorts of clients we will and won't act for. I will seek to develop each of those three meanings and to illustrate their importance. Most of my focus will be on the first, that is to say, the philosophical content of law. and I'll draw on some of the examples we use in PFL. But first, I want to pay tribute to my co-founder, Associate Professor Christopher Cordner of the Philosophy Department, as it then was, now retired, and to the founding coordinator of the subject, Associate Professor Dale Smith, who, fortunately for us, was appointed to this law school from Monash just when we were getting started. Dale's successors as coordinator of the subject, Dr. Jayani Nadarajalingam and John Maloney, the current coordinator, are also here this evening, and I can safely say without their respective contributions over the decade, we wouldn't still be going. The other thing I want to mention is that I'm planning to talk for 35 or 40 minutes. I've probably got too much here and I'll edit as I go because 40 minutes is quite long enough. And then, as Naria said, there'll be an opportunity for questions. Let's start with the philosophical content of law. An examination of any area of substantive law reveals that ideas drawn from moral and political philosophy underpin and explain how the law is developed. Mostly, the work which those ideas do is hidden from view, making it all the more important that the ideas be identified and then scrutinised. Less often, philosophical concepts are made explicit in the language which legislators and judges use, making it imperative, I will argue, that lawyers have the tools to engage with those concepts. Thinking philosophically begins with awareness, with developing an appreciation that the legal rules we've adopted rest largely on unstated assumptions or norms about, for example, how we assess right and wrong, the moral obligation of one individual to another, how we attribute responsibility to an individual for conduct, raises questions, of course, of causation, agency, and free will. The nature of the relationship between state and individual, what kind of recourse should the individual have against decisions made by government? And finally, how we satisfy ourselves that we know things and what it is to know something. The point is well made in the introduction to Philosophical Foundations of Tort Law, a 1995 book, in these terms. The law of torts concerns the obligations of persons living in a crowded society to respect the safety, property and personality of their neighbours, both as an a priori matter in advance and as a duty to compensate afterwards for wrongfully caused harm. Tort law, in other words, involves questions of how people should treat one another and the rules of proper behaviour that society imposes on each citizen for avoiding improper harm to others. Moral philosophy and, to some extent, political philosophy are likewise concerned with principles of proper conduct. And so both fields, Professor Owen says, involve a search for norms of proper behaviour, norms that may be used for evaluating the propriety or wrongfulness of particular instances of harmful conduct. Most law teaching and most law practice is concerned with what the rules are and what they mean and how they should be applied. The philosophical inquiry is quite different. It is directed at understanding why the rules are the way they are, at exposing and scrutinising the philosophical assumptions on which the rules rest, the norms used, as Owen said, for evaluating the propriety or wrongfulness of particular instances of harmful conduct. The philosophical inquiry is both reflective. What does it say about our society that the rules are the way they are? Whose assumptions are given primacy in the determination of what the rules are? And it's also normative. That is, the philosopher will ask, should the rules be the way they are? What other foundational ideas might we choose? How differently would the law operate if we made different choices about the norms we embed in our substantive law? By identifying the philosophical assumptions and choices which underlie the rules, we are inevitably in a better position to evaluate them critically. We come to realise that the foundational ideas are contestable and changeable, and we realise that we can be participants in that contest and contribute to that process of change. As the legal philosopher Nicola Lacey has argued, we simply can't analyse the common law without appreciating that, quote, the values and ideals of a political society change over time. Conceptions of conduct, agency and responsibility shift. Geopolitical and economic circumstances change, unquote. So much may be accepted, but why, you might ask, do I say this kind of philosophical awareness is essential for lawyers and future judges? The answer lies in what I'm going to call the philosophical imperative, a term which I will explain shortly. My first example of philosophy at work in the law concerns the concept of autonomy. And I'll just pause there to invite you, as you're listening, to think about what autonomy means to you. It turns out that autonomy is a foundational idea in the law of torts, but its importance is largely hidden from view. Thus, it's been said by an American academic that, quote, the fundamental doctrines of tort law are structured to advance autonomy. On his view, the law of negligence protects autonomy through deterrence by creating the risk of liability, which will constrain me from doing things which might otherwise intrude on that person's autonomy, and seeks to restore autonomy through compensation when there's been a violation. At the same time, of course, tort law constrains my autonomy by imposing limits on my freedom of action. What interesting questions they would be, I suggest, for a class in torts. You'd want students to ask themselves first, having done a bit of study of tort law, is it descriptively correct that tort law rests on conceptions of autonomy? Do I find in the case books that what's going on is a concern about autonomy? And if it is that normatively sound? Is that the way tort law should be? What about the moral norms of corrective justice and distributive justice, which others see as central to tort law? And to deepen this philosophical discussion in the tort class, we might add in the first author's view that, quote, the concept of fault imbues tort law with a deeply moral flavour. Yet another author has argued that, quote, tort law misses the moral target of culpability entirely. In PFL, we draw attention to a particular group of court decisions which explicitly invoke the idea of autonomy as a limiting factor on liability. That is, as a reason either for not imposing a duty of care, or not recognising one, or for confining the scope of an acknowledged duty of care. In the first category are High Court decisions holding first that police officers owed no duty of care to an overtly suicidal person, notwithstanding that they were equipped with statutory power to, quote, apprehend a person who appears to be mentally ill and to be at risk of self-harm. And decisions holding, and this will be familiar, I think, to students, that a proprietor of licensed premises owes no duty of care to protect an obviously intoxicated patron against the risks of physical harm arising from that person's continued consumption of alcohol on those premises. So those are no duty of care cases. In the limiting the content of the duty category are decisions of intermediate appellate courts, including the Victorian Court of Appeal, dealing with the scope of the duty of care owed by an employer to its employees. These are cases where an employee has suffered psychiatric harm as a result of having been foreseeably exposed through her work to traumatic or distressing events. The courts have regarded the employee's autonomy as a, quote, important value, unquote, counting against viewing the employer as obliged to monitor the employee's mental health or to intervene if there are signs that her mental health is deteriorating. In the police officers and suicide case, Stewart, 2 police officers came upon a man who'd, quite obviously, as he admitted to them, been on the verge of committing suicide. The hose was attached to the exhaust pipe. He told them that he'd changed his mind, so they let him drive off. Later that day, he killed himself. His widow sued Victoria Police in negligence. The threshold question was whether the officers owed her husband a duty of care. By majority, the Court of Appeal held that they did. I was a member of that majority. The High Court unanimously disagreed, and the passage to which we direct students' attention in relation to the significance of autonomy in the reasoning is from the joint judgment of Justices Gummow, Hayne and Hayden. Quote, the duty which the plaintiff alleged the police officers owed her late husband was a duty to control his actions, not in this case to prevent harm to a stranger, but to prevent him harming himself. On its face, the proposed duty would mark a significant departure from an underlying value of the common law, which gives primacy to personal autonomy. Their Honours went on. Personal autonomy is a value that informs much of the common law. It's reflected in the law of negligence. The coexistence of knowledge of a risk of harm and the power to avert or minimise that harm does not, without more, give rise to a duty of care at common law. There is no general duty to rescue. In this respect, the common law differs sharply from civil law. The common law has been described, Their Honours said, as, quote, individualistic. The civil law as, quote, more socially impregnated, unquote. Expressed in the most general way, Their Honours said, the value described as personal autonomy leaves it to the individual to decide whether to engage in conduct that may cause that individual harm. I refer then to a House of Lords decision called Reeves. I won't read the quote, but it is to similar effect about the individualist philosophy of the common law, and that a duty to protect what Lord Hoffman calls a person of full understanding from causing harm to himself is very rare indeed. I note that I'm about halfway through my time and nowhere near halfway through my notes, so I will continue to edit as I go. There are, of course, cases which turn on the autonomy of the These are cases which turn on the autonomy of the person to whom the duty of care is said to be owed. The intoxicated drinker, the man about to commit suicide, the employee who's suffering psychiatric distress because of the horrors she's observing in her work. And the law is saying, well, we won't go either anywhere or not very far with the standard of care because we respect her autonomy. Interestingly, the hostility of the common law to the imposition of affirmative duties, such as a duty to rescue, is said to rest on respect for the autonomy of the putative duty holder, the person who might be expected to do something, and the common law says, oh no, we wouldn't require you to do that. It would intrude on your autonomy. Whereas no mention of the autonomy of the police officers in the case I was talking about further. It was all about the man who then killed himself. But going back to what I read from the joint judgment, I'm sure you'll agree that that's a very rich set of philosophical statements about the common law in general and the law of torts in particular. But they're surely contestable and, at the very least, worthy of investigation. I should mention in passing, no one mentioned the word autonomy in the Court of Appeal. Had they done so, I suppose I would have asked for written submissions. We might have even asked for an amicus from the philosophy department. And that's not an altogether facetious remark. It is a bit bothersome, I would respectfully say, that the joint judgment made declarations about the meaning and significance of autonomy without assistance from anyone other than counsel for the police, who mentioned it, in one line according to the report, a very full set of submissions which were mainly about we can't constrain police in doing what they do. If the common law has traditionally been individualistic, why should that continue to be the case? Why wouldn't we prefer a more, quote, socially impregnated approach to duties as between one person and another, especially a person in a position of authority and power and actual express power like a police person? Now, the common law's conception of autonomy is highly atomistic, meaning that it views the individual as self-sufficient and self-contained, as abstracted from the social relations in which people actually live. But as we showed the PFL students last year, there are other quite different conceptions of autonomy, and the most interesting one for present purposes is the feminist conception of autonomy, which you won't be surprised to hear is relational. It's not just about blokes on their own. On the feminist view, since, quote, relationships of care and interdependence are valuable and morally significant, any theory of autonomy must be relational in the sense that it must acknowledge that autonomy is compatible with the agent standing in and valuing significant family and other social relationships. And as we discuss in the class when we talk about the suicide case, it's a very narrow view of autonomy to say, well, it was okay, it was his right to kill himself, and yet there are such profound reverberations for his widow, his children, his friends, his parents. Now, this fuller conception of autonomy can be seen at work in, for example, occupational health and safety law, which imposes a statutory duty on an employer to ensure that an employee doesn't take unreasonable risks. As WorkSafe's advertisements constantly and appropriately emphasise, that restriction on the worker's freedom of action is justified by our recognition that the death or serious injury to a worker has profound implications for the worker's family. They want him to come home. On this view, his relational autonomy is not infringed by the rule that says, no, you can't go up on the roof without a safety harness. Nor is autonomy a state of existence of which it can be said categorically that it's either present or absent. Joseph Raz, well known to all of you, for example, has defined 3 conditions of autonomy, each of which must be satisfied if a person is to be autonomous, that is, the, quote, maker or author of their own life. He or she must have the mental abilities to form intentions of a sufficiently complex kind and to plan their execution, have options to choose from, and have independence, freedom from coercion and manipulation. In short, whether a person is autonomous is highly dependent on that person's capacities and on the changing circumstances in which they might find them. More autonomous when they're sober, less autonomous when they're drinking far too much in licensed premises. More autonomous when they're in a state of relative contentment and happiness, less autonomous when they're so depressed that they're thinking of killing themselves. There's a further conundrum. If the common law refrains from intervening to prevent a person ending their own life, why does equity intervene under the rubric of unconscionable conduct to save a person from the consequences of an ill-advised transaction? Matthew and I were talking to the students yesterday about conscience, and I'll come to that, time permitting, in a moment. And what's interesting is that what justifies equity's intervention is the existence of quote, a disabling condition or circumstance which seriously affects the ability of the innocent party to make a judgment as to his or her own interests. Well, the heavily intoxicated person has a seriously diminished capacity to judge her own interests, as does Mr. Veenstra when he's putting the hose on his exhaust pipe. The decisions I've been talking about are, I want to suggest, a powerful illustration of the philosophical imperative. By that I mean the imperative for the lawyer, the law student, the lawyer, the judge, to develop philosophical awareness, understanding, and fluency. As a lawyer, I contend you need first to be aware that philosophical ideas are almost always at work in legal doctrine and very often in judicial decision-making. Secondly, you need to have a working understanding of those philosophical ideas. And thirdly, you need to have sufficient fluency in philosophical language and method to be able to formulate your advice and your advocacy to the court accordingly. What students in PFL learn, at least on my observation, is that once the philosophical door is opened, the development of these aptitudes, awareness, understanding and fluency, collectively the capacity to reason philosophically, come quite easily. Students come to realise that concepts like autonomy and culpability and corrective justice are readily accessible. You don't need to have studied philosophy to have a sense of what those terms might mean. And students realise that their own ideas and their own intuitions are as valid as those of any other student and any other judge for that matter. They learn, because we make sure to have judges and practitioners with academics in every class, that these are not academic questions. These are live questions for people engaged in the practice of the law. And to my observation, the students experience over the course of the semester the kind of exhilaration which goes with the discovery of a new language, of new insights, of new understanding. It's kind of, oh wow, is that how it works? And I realise I can engage intelligibly and intelligently in a discussion about how it works. Yes. When it was in small type, I thought it was manageable. When I expanded it so I could read it, I did have my doubts. Anyway, I'll go for about another 10 minutes. And I should have taken Charles Dickens' approach and done it by instalments over a couple of months. Yeah. Whether people would have been as avid to get the next instalment of this, I'm not so sure. But I do want to cover a couple of things briefly and then get, I suppose, must get to the other two versions of thinking philosophically about law. The next section is about explicit moral concepts in the law. And some of this is in the joint article, where we're investigating whether judges are in fact called on to deal with moral concepts, and on close examination it proves that they are all the time. You know about conscience in the statutory rule against unconscionable conduct, which I still think is a remarkable thing, that in the 21st century we have one of the principal rules governing business conduct, a rule which prohibits conduct against conscience. And what we explore in the article is all of the implications that has for judges, practitioners, advisors, legal education. I might just read that quote because I'm going to end up saying something about legal education. We argue that law students need to appreciate that these conscience-based doctrines expect transacting parties and their advisors to engage in moral deliberation. Because you can't work out whether this proposed course of action is going to be against conduct if you don't think about it morally, because the law is a moral principle. We say, quote, law students should be equipped not only with understanding of the elements of the doctrine, they should appreciate that the doctrine demands active moral engagement on the part of those who propose to transact with vulnerable people. And in the class yesterday, we were discussing how realistic is it to expect that non-lawyers in commercial settings will think and reason morally as the law expects them to do. And we argue that legal training should enable and encourage young lawyers to bring their moral sensibilities to bear on their advisory work, and legal practices should cultivate a culture of moral awareness and engagement. I then turn to criminal law. Our system for attribution of criminal responsibility is grounded in moral and political judgments about the types of conduct to be criminalised and about the justifications for punishing offenders. And these judgments, of course, vary over time. In sentencing, for example, the judge is required to assess the, quote, moral culpability of the offender. That assessment typically being central to the decision on the magnitude of the penalty. Recently, the Court of Appeal said, and I want to acknowledge my successor as President, Justice Karen Emerton, who was a member of the bench in this case, we said, in assessing moral culpability, the court is making a moral judgment on behalf of the community about the degree of blameworthiness to be attached to the offender for the offending conduct. And what we've been developing in the Court of Appeal is a jurisprudence about how to assess moral culpability where a condition, whether a mental illness type condition or profound childhood disadvantage, so affects the ability of the offender to make rational choices, that being the presupposition of the criminal law, so affects them that we should conclude, we should judge their blameworthiness less harshly. This is almost never talked about, and yet here we are in what is, I think, for the community, the most significant area of adjudication, explicitly moral judgments at work. And there is a whole really interesting set of ideas which I've only really started to discover recently about the underlying assumption on which these rules of responsibility and culpability rest. That is the notion of the rational agent with powers of cognition and volition, the ability to exercise judgment and self-control, and the ability to anticipate and evaluate consequences. As Nicola Lacey argues, the basic moral intuition is that it is only legitimate to hold people criminally responsible for things which they had the capacity to avoid doing. The next section is on political philosophy, and you'll be interested to know we had a political philosopher in PFL last week, Dan Halliday, introducing students to the contest of values which underlies the substantive law of property. Wouldn't it be interesting to spend a bit more time debating the trade-offs between liberty, equality, individuality and community, and a little less time on easements? Administrative and constitutional law are, of course, bristling with ideas from political philosophy. This might be thought to be self-evident, but how often is their philosophical character acknowledged or their contestability recognised? As Peter Kane, esteemed public law academic, has argued, the prescriptive or normative question, when should public law rules apply, or what's the proper scope of public law, is just as important as the descriptive question, what is public law? Defining the proper scope of judicial review, for example, raises fundamental questions about the separation of powers and about the relationship between the individual and the state. And I refer here to what's described as the judicial revolution in English administrative law, when between 1964 and 1985 the House of Lords changed the balance of power. It's an interesting story, but time doesn't permit me to go through it. Statutory interpretation also raises questions of normative political philosophy. Who would have thought? I'm still arguing that statutory interpretation should be a compulsory subject because, as I've said for 15 years, 2 out of 3 cases in every appellate court turn on statutes. I know it's not very intellectually rich, but it's powerfully important. In any event, there are philosophical questions in statutory interpretation, and I've argued that sticking closely to the text actually advances important philosophical values intrinsic to the rule of law. And I'll move on without listing those. And then there are some interesting examples of contested philosophical judgments at play in High Court decisions on the implied freedom of communication. So that's the philosophical content of law. It's everywhere. The second meaning of thinking philosophically about law was thinking like a philosopher. And what I came to learn as a practitioner, and even more so as a judge, was the absolute importance of clear thinking, clear writing, and clear argument. These are, of course, the hallmarks of the best philosophical writing to which we seek to introduce PFL students. In his book, Jurisprudence, Theory and Context, Professor Brian Bick argues that reading philosophy and participating in philosophical discussion develops the ability to analyse and to think critically and creatively about the law. Quote, "Philosophy trains one to think sharply and logically. One learns how to find the weakness in other people's arguments and in one's own. And one learns how to evaluate and defend, as well as attack, claims and positions." And that late great thinker John Gardner argued that such were the similarities between legal and philosophical training, that is, training about argument as such, that they should break away from social sciences and humanities and form a school of argument. What I find so attractive about analytic philosophy is that it can distill a phenomenon or a concept to its essence and thereby open the way to a clearer understanding of the world. The object of that kind of conceptual analysis is to simplify and clarify. The tools employed are linguistic clarity and logical rigour. And given that law is language, in statutes, in judgments and in legal argument, and given that clarity promotes understanding, these are tools of the first importance for lawyers. And I go on to explain how I found that distillation and simplification were essential to the work of judging. Now to the third and final meaning, philosophical self-awareness. Philosophical self-awareness means recognising the decisions about what kind of legal work you do and how you do it necessarily involve moral and political choices. As I said to the PFL students in week 2 this year, your choice as to where you seek employment as a lawyer is a moral choice, because you're choosing to put your legal skills at the disposal of the clients of that legal employer, whether private or public, and hence to facilitate the furtherance of those clients' various commercial, governmental or regulatory objectives. And once you've signed on, you won't or won't necessarily be able to object to working for a particular client whose activities you find personally objectionable. In their wonderful book, Inside Lawyers' Ethics, Christine Parker and Adrian Evans illustrate the moral character of legal practice by postulating 2 different types of lawyers. And you've no doubt been through this in disputes and ethics, but one is the responsible lawyer who sees fidelity to law as a moral enterprise in itself. The other is the moral activist who has her own, quote, convictions about what it means to do justice in different circumstances and seeks out ways to act out those convictions. My point for present purposes is that learning how to approach these moral choices is another reason for learning to think philosophically about law. Once you learn to see lawyers and judges as moral agents with moral responsibilities, you'll never think about legal practice in the same way again. What does this mean for legal education? And I'm on the last page. My contention is that legal education has no alternative but to respond to the philosophical imperative. Once it's accepted, as I hope it is, that philosophical ideas are in play at every stage of the development and application of substantive law, it must follow that a properly trained lawyer needs those three aptitudes: philosophical awareness, understanding, and fluency. As I've sought to demonstrate, the capacity to think and reason philosophically is essential if the lawyer is to understand fully how a legal rule has come to take its present form and what its guiding purposes are. And even more importantly, that capacity is essential if the lawyer is to fulfil her professional duty as advisor and advocate, and one day as adjudicator. Curriculum development is not only beyond the scope of this lecture, but also beyond my competence. But let me just finally suggest three possibilities for how this might be done. The first is the model adopted by the New York University Law School, an eminent law school, as many of you will know. At NYU, Professor Leah Murphy, a graduate of this law school, has for many years taught introductory courses in moral and political philosophy to law students. The second possibility is to build a philosophical foundations component into the teaching of every substantive subject, as I was suggesting before about a discussion in tort about whether autonomy really is the foundational idea. As you're probably aware, the past 3 decades have seen a proliferation of books entitled, quote, Philosophical Foundations of. There are about 15 of them now, one or more than one for every subject. The third possibility would be a refashioning of legal theory, which, as you know, is a compulsory subject, which receives, at least from what I hear, what might be described as mixed reviews. I've had the pleasure, through my discussions with Julian Semple about the topics for tonight, of reading his reading guide for his stream in legal theory. And I said to him before, where's the heart fuller debate? It's not like any legal theory subject that I have known, and the point is the exciting, irresistibly interesting range of topics in Julian's reading guide seems to me to pave the way for a refashioning of legal theory so that it provides the introduction to philosophical foundations of law for the reasons I've been arguing. So I think my preference would be for a combination of the second, that is a bit of philosophical foundations in the substantive subjects, and legal theory being a subject about philosophical foundations, so everybody does some of it. It's not everybody's cup of tea, but I think I can say, after 10 years in PFL, everyone who comes in seems to go out with an intellectual spring in their step. What matters, I think, is not so much philosophy standalone, but understanding philosophy as integrated or fused with law. Thank you very much.
Thank you, Chris, for a fascinating and insightful lecture. I know I personally really want to hear all the bits you skipped. So looking forward to your article. We now have some time for a brief Q&A. So if you have a question, please raise your hand. We'll pass the microphone to you. And then if you could just kindly pass it back. Thank you.
Hello, Justice Maxwell. My name is Abdullah, and my favorite part of your talk was that you're essentially advocating and interdisciplinary approach to legal education.
Yes.
And my question is, do you think that we should go even beyond philosophy and also incorporate the things that tell us about what shaped human behavior, so evolution, anthropology, psychology with cognitive bias? For example, I'll just give a brief example, if that's okay. You raised, it's always nervous asking questions in front of a lot of people.
As we say in PFL, there are no stupid questions.
Well, for example, the concept of conscience and equity, I had to write an equity essay for an elective, so not just principles of equity, but an extra one because I really enjoy it. And to me, when talking about where conscience comes from, I couldn't unsee the fact that human beings have in common with every social mammalian species out there a concept of fairness that's built on game theoretic principles. Now, when we're asking ourselves, where does the human love for fairness in interpersonal dealings come from? You cannot unshackle that millions of years of molding of our behavior away from these concepts that come in, quite late. And so my question to you is, do you think we should begin incorporating those sorts of areas into legal education as well as philosophy?
Look, I don't. I'm answering that rather bluntly because I think philosophy is in a very special position for the reasons it's uniquely embedded in the very rules we have to apply. Having said that, I'm a strong advocate for interdisciplinary engagement. And one of the problems of law as a discipline is that it's rather self-satisfied and thinks that it knows all the answers when it plainly doesn't. And I've learnt a lot in the field of criminal law by engaging with forensic scientists and psychologists, because their work feeds in crucially to the work of the criminal courts. And I've also launched a book about interdisciplinary legal practice, which is another fascinating field. So yes, I'm an absolute believer in law learning from other disciplines. But as I say, I think my contention for the moment is that the fusing of law and philosophy is not replicated in relation to any other discipline, including science. The other thing, of course, is I'm trying to make my ambitions for this little campaign realistic. And if I've got to convince the Dean to include anthropology, psychology, geography, then you know what I mean. But I think where considerations of that kind bear on the understanding of a doctrine, then it seems to me, yes, of course. Because the better informed we are, the better we understand that law isn't a self-contained, complete body of knowledge, but a set of rules we've developed for entirely instrumental purposes. The more we appreciate that, the better.
Thank you.
Stay with me, everyone. Thank you. Thank you very much for that very inspiring lecture, Justice Maxwell. I would like to take you to the earlier arguments that you had about values and beliefs. I would like to take you back to possibly a case that actually Australia is going to be very fundamental in, and that's with the Julian Assange case, where basically values and beliefs of Julian are in contradiction to what the Americans actually claim as a contraception, a breach of actually the judiciary values as the Americans have described. But Julian actually has always defended his argument that basically the world has a right to know. I'm autonomous. I actually have certain values and beliefs, and I work with a social construct within WikiLeaks. And even actually with his legal advisors, he has always actually acted in the precedent of actually that information should be out there. And I would like to hear your view in that context about values and beliefs in your context.
Yes. Well, I've got a number of thoughts, but the starting point is that the notion of the citizen who can decide for himself what the limits are is untenable. Quite untenable. There is, of course, a rich literature about civil disobedience, which long ago I wrote a thesis about, and Julian Semple has more recently written very interesting articles about it. And there is a moral case for saying, I know I'm not allowed to do this, but I'm going to do it because of the public interest which I believe will be served. Or I will disobey the racial segregation laws in the US in the 60s because I believe in racial equality, and I will go to jail. I accept that the law will apply to me until the Supreme Court overturns it, but I will break the law because my beliefs, my values either justify or require me to do it. Now, views differ about the public interest value of what Assange did, but for myself, it seems to me it was of great significance, just as Snowden's disclosures were of great significance. And my personal view is that governments are much too secretive, much more secretive than they reasonably need to be. But that's not much help to Julian, because he's knowingly published material in the face of a legal framework which he would, I imagine, understand is likely to view his conduct as illegal. I think that's about all I can say. Meanwhile, of course, you have campaigns to change the laws, or you run cases in the High Court of Australia on the implied freedom of communication, and you say, well, that prohibition is invalid because it prevents me expressing a political view. Or in the US, you run it on the basis of the Bill of Rights. That there are foundational values in the Constitution which mean that the law which would otherwise apply to me is unconstitutional. Those arguments are also available, along with arguments in the court of public opinion.
Good evening, Justice Maxwell. My name's Armin. I haven't had the pleasure of having you as a teacher, but I'd like to...
Sorry, you have or you haven't?
I haven't. But nevertheless, I'd like to hear your opinion as an educator. Do you think it's better to teach philosophical legal reasoning from first principles at the start of legal education? Or do you think it's better to be exposed to some law unconscious of those principles and then to introduce those kinds of rigours?
Yeah, I think I take the second view. As I said with the torts example, it seems to me you could have, I don't know what the torts syllabus looks like, but you could have 6 or 8 weeks on the tort of negligence and then start talking about autonomy, because people then at least have a sense of the area of discourse. But certainly I think the more familiar you are with the way the law is structured and the way it works in practice, the easier, the more comfortable you will feel engaging with these philosophical questions. So yes, I don't think it's something you would do in week 1 of year 1. But I think I wouldn't leave it too late, because if I'm right that this is at the heart of most law, then it needs to be on law students' radar pretty soon. But your point is right. I think it absolutely requires a foundation.
Hello. Oh, sorry. You have a question as well. Sorry. My name is Sophie. I just had a question in terms of changing the actual law itself. Does there need to be a coordination between the understanding or agreement or the philosophical underpinning of a legal principle for there to be change? For example, if a practitioner has a certain view on a legal principle, does that need to be in coordination with the judge to be able to change the common law? Because what is the end goal if we want to be aware and to be able to explain ourselves? But what is the end goal then? Because it's all well and good to know the philosophical understanding, but how do we actually change legal principles?
Well, I think to go back to the Stewart case, the one about the suicide, it's a really good question. And as an advocate in the three levels, there was the trial judge, I think, who said no duty of care. She appealed to our court, we said by majority duty of care. Obviously, it depends what argument you're putting. If you're for the police, your argument will be this would have infringed Mr. Veenstra's autonomy. If you were for his widow, you would be wanting to convince at least the Court of Appeal to move the dial. In other words, to say, well, yes, in Victorian England, there was great valuing of autonomy, but, Your Honours, we're in the 21st century now, and there's no binding authority which prevents you finding a duty of care, and you shouldn't allow autonomy to stand in the way. There'll be a contest about that. There would then have been another contest in the High Court, which would presumably have ended up the way it did. My proposition is that in order to be a good advocate in that setting, whichever side you're arguing, you need to have some familiarity with the work which autonomy does as a philosophical concept, the room for debate about its content, to what extent it would have applied. It was a meaningful description of the act of Mr. Veenstra in presumably a state of deep depression. Is autonomy a meaningful term for the court to be using? Those are the sorts of things that, as the High Court decision shows, proved to be really important in the decision, in her failing, and my argument is you need to have an awareness about autonomy, some understanding of it, and sufficient fluency to say, well, Your Honours, if I can just refer you to what Professor Raz said about autonomy, Your Honours will recall there are 3 conditions for autonomy, and the judge will say, yes, of course, we recall that from when we did philosophical foundations of law long ago. But that's... and it's partly why I've campaigned to bring academic writing, including relevantly legal philosophy, into the work of the courts, because this is not something that you expect the judge to be conversant with necessarily. Does that answer the question? Yeah. Law reform's a different area, and all students here should think about getting involved with Liberty Victoria or Amnesty or Prisoners Action Group, to get involved in thinking about, normatively, about how the law might change. I had 3 or 4 years with Liberty Victoria, one of the most interesting periods of my life as a lawyer, because suddenly you're having a discussion about, well, should we criminalise hate speech? Can we put limits on freedom of assembly, which government were wanting to do 20 years ago, those sorts of things. And there not representing a client, you'll be able to give vent to your own views. Do you have a question? I'm not soliciting questions. I'm happy to answer them, but I'm sure a number of you are dying to go home and have a hot chocolate.
Yeah, we might leave this to the last question, and if anyone else has a question, obviously we'll be having canapes outside, so you might be able to grab Chris for a question. So, no, you didn't have a question? Okay. Okay, straight right at the front. Here we go. Harry, hands over to you.
Thank you for your presentation. I just have a more open-ended question. So you mentioned a lot about autonomy. what are your thoughts about legislation regarding euthanasia and patients who can reject life-saving medical treatment, such as like Jehovah's Witnesses?
Well, it's a terrific question, and I suppose I would say the public debate and the parliamentary debate about the voluntary assisted dying legislation was philosophically saturated, including with ideas drawn from religious thinking, obviously, about the sanctity of life and so on. And it's really just another way, I suppose, of illustrating that what parliaments and courts do is very often morally infused. Now, you would have a view and I would have a view about where the line should be drawn and what requirements there should be before a person can take advantage of the procedures under the legislation. There's an argument I've been reading lately, which is there are too many hurdles to get over, takes too long, and that those who would satisfy any criteria of autonomous choice are nevertheless not able to avoid dying in pain. As to conscientious objection, that's a really different issue, of refusing blood transfusions. That seems to me to be a matter of autonomy again. And if one's religious belief is such that when the doctor says, look, you know, you're going to bleed to death, we need to do something about it. If you say, well, my belief is that God will take care of me, seems to me the law does nothing about that. One of the really interesting cases, which it didn't even get in the long version, but perhaps I'll put it in the published version, is a case about a man who was badly injured in the soccer stadium riot, Hillsborough, and was in a vegetative state and all brain function gone. And the question that came to the House of Lords was whether the health service, which was keeping him alive, was obliged to keep doing so. They sought a declaration from the court. And there's an interview with Lord Hoffman, who was in the Court of Appeal when this question came up. And as he recounted it, the three judges, because they had to get the decision done quickly, one said, I'll do the facts. Another one said, I'll do the law. And Hoffman said, and I'll do the moral philosophy. And the judgment of Hoffman is fascinating because it's not refusing medical treatment, but it's a related set of questions. And Hoffman says, well, we've got conflicting issues here of autonomy and dignity. And because this person is in this state, he can't decide for himself, so we have to postulate what choice he would make as an autonomous individual. And we conclude that if he knew that continuing to be fed would mean continuing to lie in a vegetative state until he dies, he would choose not to. Anyway, it's one of the most philosophically rich judgments, because I suppose rarely that kind of contest of values was right up there at the point of decision.
Sorry to have to cut that Q&A short, but I'd just like to take a moment to thank you, Chris, for such a genuinely engaging and insightful lecture. We are truly very privileged to not only hear from you this evening, but also to have you as a member of the teaching staff here at Melbourne Law School. So could everyone please kindly join me in thanking Chris?
Thanks very much. Thanks very much.